Judiciary Committee, it's been a fun, long day. We are going to stick around as long as we get and keep a quorum. So our plan is to have 2 more hearings next week, but we know time is starting to run out, but we will take the time we need to hear these bills. And so if we don't get to your bill today or can't take action today, we'll revisit it potentially next week. I'm stalling because we have a quorum within earshot, I think. But Senator Rhett is going to lead us in a long word of prayer, and I'll say amen when we get a quorum. Are you mic 4? Are you mic 4 or which mic are you? 5?
Yes, sir.
All right. Go ahead, please.
Thank you, Mr. Chairman, and thank you all for coming today. We're thankful for this opportunity to be able to come together and do the people's work. Right now, we're also praying for a quorum because we all are busy, and I'm trying to extend this prayer out. But we ask for your wisdom and guidance. We want to feel you in our feet, our hand, and our mind. And when we feel a little shake, we'll notice you giving us your wisdom. We ask these things through the Creator. Amen and amen, y'all.
Amen. If you want to be heard on the bill and you have not signed up, please come up here now and sign up. Glad you got a cup of coffee. Leader Hatchett, you cost us 2 more minutes.
Well, you were out of coffee like the other chairman do.
Yeah, I can't afford it. All right. Representative Gaines, come on up. We're going to House Bill 288. And for the committee's information, that's the right word, we have a substitute on this bill that the author is going to explain that does add a little bit more to the bill than what passed the House. And so if the committee's comfortable, it's a little bit late arriving, but if everybody's on board, then we can consider the bill with the new substitute. So we're working off of LC 394772S. Is that right? Yes, all right. Hold on, I pushed the wrong button. Now you're on. The floor is yours. Thank you.
Well, I'll start by explaining the new portion, which is Section 1, and it should be somewhat familiar. The Senate passed a very similar language, 45-5, 2 years ago, but this is ensuring that those who qualify for sheriff at the time of qualification meet the standards that they would have to qualify within 6 months of serving in office. And while we're trying to do that, in particular, there's been a legal issue in Macon County, which I think we have some folks from the Sheriff's Association here that can talk to that a little bit more. But it's been a legal battle and really complicated, where the person who got elected was never able to get that qualification. And so this would shore that issue up. We got this out of House committee unanimously, but it was, I think, the day of crossover, the day before crossover, and we came to an agreement in the House that is slightly different from what the Senate passed before. And what it does is, if someone's a first responder, if they've served in the military, or if they're a former state, local, or federal law enforcement officer, then they would still be able to wait within 6 months of qualification. And I think that satisfied any concerns in the House. So that's Section 1 of the bill. Section 2 of the bill is what passed out of the House on 288. And what it does is ensure that if a law enforcement officer is accused of having a credibility issue, a so-called Giglio list or Brady list, that it provides due process for officers to ensure that they can clear up credibility issues. And I do have a brief amendment that I think addresses the one person who was concerned with the bill. We've worked with PAC and others to get this in a very different place than where it originally started when I introduced it. I think we largely have agreement on the bill, but how this would play out in in practicality is post would become would review any issues of credibility, and so it does provide officers with the opportunity to have due process. Right now, a DA can simply put an officer on one of these lists, whether it's written or unwritten, and then that officer can no longer be called as a witness in a case, and or they may never be able to get another employment opportunity because they've been put on a list without any opportunity for due process. This bill puts it in post, so there would be an investigation, which would also ensure if an officer has acted poor, and has a credibility issue, they could be removed from that after that investigation. So that's section 2. That's what the bill does. I'm happy to go more in depth as you want, but I know we're running late.
Mr. LaRusso, do you want to add anything before we take questions?
No, the question of, thank you. The question of putting the investigation in the hands of Post was particularly important to us as the FOP, the Georgia Association of Chiefs of Police, Georgia Sheriff's Association, and PAC, because if there is an officer who has violated their oath and they have committed an act that would require them to be removed, that Post is the opportunity to do that. They could actually take that investigation and immediately begin proceedings to decertify them.
And Representative Gaines, you mentioned a proposed amendment. Tell us about that, if you will.
Sure. So on line 136, and Legislative Council has this, I believe, in hand as well. After the word attorney, it would remove the rest of that paragraph. So from the word for through the word counsel. And it would change that language to read, so a Giglio list means a list of names compiled and maintained by a prosecuting attorney. And this is where the change begins, of officers disqualified from trial testimony because of identified or alleged issues of credibility or bias. And that was from someone who's here at the DeKalb County DA's office, and we were just working with PAC back into back. I think we're all good with that.
Is that Mr. Mann that's here with
Yes.
us? Where's Mr. Mann? Oh, right here. Okay. And so my understanding is everybody then will be on board with the bill. Everybody agrees with that change? Okay. All right. Any questions from the committee for the author of the bill? Mr. Mann, do you still want to be heard on the bill?
No, that was my comment.
Okay. So we will, what's the pleasure of the committee? Is it do pass LC 394772S, the committee substitute? Is that right? So there was a new substitute that added that first section. Okay. And there's a motion from Senator Parents, a second from Senator Rhett. Does anybody want to offer the amendment? Do you want to offer them? Is everybody clear on what the amendment does? We're good on the wording of the amendment. All right. Amendment from, do you want to, yeah.
So the amendment will be on line 136, starting on line 136 after the word attorney, replacing for purposes of compliance with the United States Constitution or ethical standards relative to witness credibility and required disclosure of certain evidence to defense counsel, and you're replacing that with officers disqualified from trial testimony because of identified or alleged issues of credibility or bias, and that is underscored.
All right, we have offered an amendment from Senator Parent. Is there a second? Second from Leader Jones. Any discussion on the amendment? All those in favor of the amendment, please say aye.
Aye.
It is unanimous. Going back to the motion to pass by committee substitute now as amended. All those in favor, please raise your hand. It's better than saying aye. It is unanimous.
Awesome.
And is this one I'm carrying in the Senate?
Yes, sir.
All right.
Thank you so much.
Made the bill a lot longer, than I thought it was going to be.
Thank
all
you.
right,
I appreciate it. Thank you.
Thank you.
All right. Let's go back to the top of the agenda, House Bill 162. We are, Representative Hagan, welcome back. We were working off the version that passed the House, LC 481476S, is that right?
I believe that's right. That's not the one I'm working with my notes. But is that right?
Say that one more time.
I show LC 481476S, is that right?
That's not the one I have.
Yeah, I had 1348.
Come up here, let's look at what you have.
We have, yes.
All right, they're going to take a look at it and come back. Hold on one second. All right, let's go to House Bill 378. Man who was dodging tornadoes over the weekend and came back alive, ready to fight.
That nearly got me, Mr. Chairman.
Yeah,
That nearly got me. Now, I have been,
tornadoes is much worse than anything around this building, isn't it?
It is. It is. There was a storm that just a little squall came through not too long ago, Mr. Chairman. But I will say we do have a resilient house that can.
Working off LC 481455, right?
Yes, sir. I think that's right. I haven't had the bill in front of me, but I trust you.
Well, the last person didn't. So you may want to make sure I got the right one.
I believe you, Mr.
Okay.
Chairman.
All
I
right.
believe that is
Floor
the
is
right
yours.
one. And, well, let me thank you, Mr. Chairman, and members of this esteemed committee for hearing my bill today. It is a very short bill, so I have had ChatGPT make a very long explanation for it.
No one signed to speak on the bill.
You want to go ahead and make a motion, Mr.
No,
Chairman?
tell us what it does real quick.
I'll let
But
you.
don't make your explanation. You could read the bill quicker than you're explaining it.
House Bill 378 is a simple yet impactful piece of legislation designed to enhance transparency, accessibility, and efficiency in our state courts.
We have anybody else want to be heard on the bill? We have a motion to pass from Senator Steele, a second from Leader Hatchett. All those in favor of the motion, please raise your hand. It is unanimous. Who's carrying the bill in the Senate?
It'll be Senator
It's
Hatchett.
a governor's bill.
Just one quick question.
Yes, sir.
Does this only impact citizens of Georgia, or in the contest? Does this apply to the contested
This-
area between Georgia and Tennessee as well?
Well, thank you for the question. It may apply to those in the contested area, those
Okay.
stranded Georgians.
Did they call you about
That's
this?
right. We call them the Rocky Top Rejects. Thank you, Mr. Chairman.
Come back anytime. Thank you. All right. Got it figured out. Was it the right one? That's the right one. Come on back up. Representative Hagan. House Bill 162, LC 481476S.
That is correct.
Floor is yours.
Thank you, Mr. Chairman and committee members. If you were on this committee last year, you probably remember this bill. It updates our First Offender Act. What it does currently, if a person uses a first offender plea, their records are sealed upon the successful completion of their sentence. This bill would require that they be sealed upon sentencing. And the reason this has become necessary is for many people, by the time they have completed their sentence and successfully, and then that becomes a non-conviction, these records that were not sealed are on the internet. And it is, in effect, made our first offender law that was put into place in the 1960s to make sure that someone who makes a bad decision, an isolated bad decision, and doesn't make another one, it's not given the same effect that it was originally intended to do. So this bill would simply, if a judge agrees to and accepts the first offender plea, then the records would be sealed upon sentencing. And of course, if the sentencing is violated anyway, the judge would have the ability to unseal those records in that situation. But Mr. Chairman, given the shortness of time, I can talk more about this bill, or I can just answer any questions that the committee might have. It's the same bill that we brought last year. That substitute, we added the Pardon and Parole Board as an entity that would have the exception there. But otherwise, it's the same bill that passed out of this committee last year.
All right, anything to add, Mr. Askew, at this time?
Just here for questions.
Are any questions for the author or Mr. Askew from the committee? We have one person signed up in opposition to the bill. Mr. Weaver, you want to come up? Good afternoon.
Good afternoon, Mr. Chairman, members of the committee.
in order to be respectful to the author and to the proponents of this legislation, it must be noted that my opposition to the bill is technical in nature, but I have to maintain respectful decorum before this esteemed committee and make sure that I follow all the rules of procedure here. Before I begin, I'm going to do it. I'm not an attorney, but I need to put another dollar into the jar, but this time I want to put a different dollar in the jar. It's going to be a silver certificate. I have to do
My 5-year-old took your coin, by the way, that we put in there. Well, I can't give him all the money. He loves coins. That's why there's no coins
That's
left.
a star note, so that's worth about $10. I think. So keep that. Give it to him. Might be worth $100.
He doesn't think a dollar is worth much. He loves the coins, though.
Well, I can bring more of those for him next time, perhaps. I submitted a letter to the committee. I hope that each of you read it. But to cut straight to the chase, if the committee would entertain the notion, I would invite the committee to please consider lines 43 and 44 of the bill, and then lines 77 and 78, and also, I believe, lines, I've got to find it. It's towards the end, I think. 187 and 188. All three of those lines are similar in their verbiage that was included based on what the Georgia Bureau of Investigation wanted over in the House. I do have a concern there based on the Roberts Court's holding under Bruin. And actually, the Georgia Supreme Court recently, under a case called Christopher Macy versus the state, Mr. Macy raised a valid prima facie Second Amendment claim, notwithstanding his status as a felony first offender, and the Georgia Supreme Court recently reversed and remanded with instruction on a 5-4 decision that might be violative of his constitutional right to keep and bear arms based on the Bruin Court's decision. And I think what the Georgia General Assembly is doing here is we continue to weave this kind of stuff into the law, and I don't think that the legislature is fully appreciating the fact that you legally cannot cite public safety as a reason to disbar someone from having access to a firearm. Under the United States Federal Supreme Court Bruin decision, the court said that there has to be a sufficient historical analog. It's not just a public safety, and they actually rose that concern to a strict scrutiny analysis, and they eviscerated an intermediate scrutiny means end public safety analysis whenever the court evaluates that claim. And Judge LaGrua, writing for the court in the respectful opposition with the 3 justices whom Associate Judge LaGrua was able to write for and was authorized to pen the dissent for, said that they think that Rahimi is sufficient to answer the Bruin question. However, the 5 justices that concurred that there may be a concern there, they disagreed. And I actually called this, the Chris County Superior Court clerk today, was where the case originated from, to see if that court has taken any further action based on the remand. And unfortunately, the clerk that works with the judge that handled that case was actually in court at the time, so they were not able to provide a definitive yes or no. I'm not getting involved in Mr. Macy's case. That would be inappropriate. But what I am trying to say is that if a person is sentenced under a probated deferral to a felony first offender sentence, we now, just like I told you last time, you can't make this stuff up, right? It's coming from right next across the street. Our judicature, based on the federal judicature, is saying that you just can't, that's not an appropriate, it's not good. You can't just do that. And I'm letting the legislature know to the best of my ability, now that the issue has been finalized next door, that there's at least 5 justices on our Supreme Court who seem to agree that the institution of possession of a firearm by a convicted felon or felony first offender may, at least in part, be unconstitutional. And to the extent that the underlining language references the licensing statute regarding the transfer, you might say, well, it doesn't impute a 1611-131 instance per se, but transferring the firearm is contingent on the ability of that offender to be able to lawfully possess under a NICS check for one of their convicted felon or non-convicted felon status. So I just would hope that the committee is acceding to the concern and it's well taken. It's not to be mean. I support the bill as a whole, but again, in respectful approbation of the decorum that this committee has to maintain, and the posture that I have to maintain in presenting these concerns to the legislature, I had to sign up in respectful opposition, Mr. Chairman.
All right, thank you, Mr. Weaver. Any questions from the committee? Thank you. Do you have anything else you want to add, Representative or Mr. Askew? Chairwoman, sorry.
That's okay.
You're
I don't-
chairman now since you came here
Yes.
last year.
Yes,
So,
sir. No, I don't have anything to add. I do not agree with the gentleman, but I respect his right to come in and speak. Legislative Council felt that this was an appropriate add to put into the bill at the request of the GBI, and I agree with it being there. And
all right. Any further questions from the committee? Seeing none, what's the pleasure of the committee?
Make a motion to pass, Mr. Chairman.
Motion to pass from Senator Parent. Is there a second? Second from Leader Hatchett. All those in favor of the motion, please raise your hand. It is unanimous. Who's carrying the bill in the Senate?
Senator Cowsert.
Senator Cowsert. All right. Thank you.
Thank you, Mr. Chairman. Committee.
All right. House Bill 131. Representative Reeves, come on up. Let's see. We're working. I was trying to find my LC. We have a committee substitute, which is LC 620194S, and I know you will do this, but please explain to us, of course, as you present your bill, highlight the difference between this version and what passed the House.
Absolutely.
Floor is yours.
Chairman Strickland, members of the Senate Judiciary Committee, House Bill 131 is another bill this year to reduce burdens on hardworking small business people in Georgia. The self-storage statute is a unique statute. It is Code Section 10-4-213. It was enacted in the 80s or 90s, and since that time, 32 states have modernized their self-storage industry in a way that you'll hear from some hardworking small business women would benefit small businesses in Georgia. There are about 1,500 self-storage owners in Georgia. I'm sure most people in this room have used self-storage at one time in your life or another, and think about that. When people lose a parent, or when someone moves into assisted living, when they're going through a divorce, when they're in college, or if they've gone through financial issues and they've got to store things and live somewhere temporarily, they need to have as economical as possible storage. This statute provides direct notice to a customer when the notice or when the customer becomes delinquent before a sale can occur of the contents in the storage unit. And it also requires an advertisement of the sale in a way that produces 3 bidders for the sale of the contents of the storage unit. And more times than not, the self-storage units find when somebody quits paying their self-storage bill and they notify the customer directly as required by the statute, the customer just says, you can have it. And the ad runs in the paper twice. They can't complete the sale until they get 3 bidders at a sale. And over time, every year that goes by, more and more of these 1,500 self-storage units have found if they just run that ad in the paper, those 2 ads in the paper, they don't get 3 bidders. They've had to turn to other methods of advertisement. Social media, the internet, many other forms of marketing in order to get their 3 bidders at the sale. However, the customer who has fallen behind on paying the bill, they still get direct notice under the statute, regardless of the newspaper ad, the internet ad, whatever. But the current statute has fallen behind 32 or more other states in requiring 2 newspaper ads. That slows down the process, and here's the cost. The biggest cost of that not only is the delinquency to the self-storage business person, but paying customers, that unit is tied up, so it causes a financial loss for the small business, and it makes things more expensive for paying customers. So this is something that would bring Georgia into national standards, commercially reasonable standards. And Chairman, you asked me to explain the substitute. We heard from some lenders who said sometimes there's a motor vehicle, motorcycle, trailer, watercraft, or recreational vehicle parked at a self-storage unit. Usually that's parked outside. There currently are some DMV requirements. If you find one, you have a tag or a VIN. But in addition to that, what they have done in this substitute that is before you is it says under those circumstances, you still run one newspaper ad for cases that there's one of those vehicles there. And in all other cases under this sub, which is the one that passed the House, any commercially reasonable means that produces 3 bidders, that's an appropriate sale. So some communities, that's going to still be a newspaper ad. Other communities, that would be internet or some other form of advertisement that yields 3 bidders. You'll hear from these ladies who are here to testify. Often, you know, the bids are $20, $25, because you're dealing with stuff that somebody's abandoned that is of little or no value and is tying up a paying customer. So for the sake of our small businesses, we would ask for approval of this good modernization of Georgia self-storage law in a way that serves customers while keeping due process for the folks who fall behind in their bills. I would like to say that you know, there are fights about legal organs. This shouldn't be one of them. This is not one of those cases where the legal organ and a legal ad is a legal transaction where somebody's rights are in jeopardy. Here, under the statute, before this bill was filed, the self-storage is required to contact the customer at the address and information the customer provided, and they do that because that's the way they get paid. And that doesn't change. All the consumer protections to the customer are still there. One thing I'd like to address, there was a bad lawsuit in the Augusta area for a self-storage named Monster Self-Storage. And I read that case, see if anything in this bill addresses that. That self-storage, they didn't follow any of the law. They totally disregarded the law. They didn't contact their customer. They didn't run a newspaper ad. They didn't do anything. They didn't. That person who was managing that self-storage, they completely disobeyed the law, and they didn't have a sale. They just threw the stuff away. So we shouldn't legislate based on extreme situations like that. I hear a lot of money was paid in that case where wrong was done. This brings Georgia into the national standards in this industry. It helps small business people. It protects due process for customers. So we respectfully request approval of that. Mr. Chairman, I'd be glad to answer any questions, and I know there are some business people who have signed up to speak.
On the amendment, is there a purpose in being that narrow with the amendment from your standpoint?
On the vehicles, that is language that the lender community, credit unions, community bankers, I believe Georgia bankers reviewed this as well. These are things where there are loans on them. Now, I would like to point out under existing law, you know, they're going to have capabilities of checking the database and obligations to notify those lenders, but this just provides one more form of notice to those third parties who may have an interest.
Okay. Any questions from the committee for the author?
And usually I've gotten 2 or more no votes in the House. This one passed unanimously.
Well, now you have a question. Leader Hatchin.
Thank you, Mr. Chairman. We've dealt with legal organs before. We've dealt with them this year. Typically, when a bill like that comes up, I hear from my newspaper guys. I got a good relationship with them. I haven't heard from any of them. And my understanding is this is, well, I guess this is a 2-part question. Number one, have they pushed back at all on this?
I know Mr. Marsh is signed up to speak.
Okay.
I've spoken with him. You know, we've heard them out as much. I don't believe they've taken they certainly, you know, they aren't excited about anything that changes ads, but I would like to say some people are on the warpath on legal ads and legal organs. I am not. I know as a lawyer, I see those, there's a place for that, but these ads, they're advertisements for sale. So
right.
they're not a legal ad for a legal proceeding.
Well, that was going to be my next question is typically, you know, we're dealing with protection, and when you are going to take someone's stuff, you want to make sure they're notified. But these ads run after the notification has been made to the owner of the storage unit. So this is not a legal ad like you would foreclose. Well, I guess foreclosure is different, but for a bankruptcy or something like that. This is after the owner or that has the stuff in the unit has been notified. Then you run this just for the sale. That's it.
That's right.
Okay.
Exactly. And Georgia has a consumer protection statute that is the contract that is signed at the self-storage that says, hey, if I fall behind, here's how to contact me. So if you move or whatever, you could change that. And you're going to hear from these business people. They never get paid in these sales, so they're contacting that customer, and these customers who don't respond, they just don't want to. They've given up on the stuff in almost any cases. But you've got a diligent bunch of folks who follow the law, and this is something that in Georgia and other states would reduce a burden on these small business people. It's been tried in other states. These internet ads are what is getting those 3 bidders to the sales anyway, so it's eliminating a cost to small businesses that's passed on to customers.
Okay, thank you.
Any other questions for the author? All right, thank you. We'll have the individuals come up to speak on the bill. You'll have really good handwriting, but it's so good in cursive. I'm having trouble reading the first name, but Miss Ballard? Come on up, Miss Ballard.
Sorry about the cursive.
Oh, that's okay. It's better handwriting than I have. Is it Miss Ann? Is that right?
Yes.
Okay, come on up. Do you want to come together?
Yes, please.
Miss Jane, is it Sauls?
Yes, it is.
And Megan Armstrong. I can read that. All right, come on up. We'll take you as a slate. Unless y'all want to go one at a time, however you want to do it.
As the oldest, I'll go first.
All right. Now don't talk at the death, because if one person leaves, we lose a quorum, and
No.
a week will pass before the bill can be available again.
Ready to go. And,
All right.
and got our information. My name again, Ann Ballard. And we thank the chairman and the committee for hearing us today. Managing over 80 facilities around the United States, and of course being a Georgia-based management company from the very beginning, and having served 2 terms as president of the Georgia Self-Storage Association, and we have another past president here and a current board member here. I just thought a few numbers I would throw at the wall and see if that wouldn't answer some of your questions and concerns. So for the year 2023, we wrote 4,489 letters to people who had not paid their bills, and we had to start the auction process. That left 1,490 units in the sale, with people owing us $1,003,221. We recovered $161,000, or 22%. In 2024, that number dropped to 17% recovery. So the owners are not getting back anything close to what they have lost, and they can't rent the unit until we finish this process. The good thing is that we had 416,228 views of our ad for the items online. And that's predominantly, as our sponsor has told you, where we get the most activity to have the 3 commercially reasonable people bidding on the items, and got 16,789 bids that way. And with the process, our managers start by, of course, calling. I'm sure many of you, if you've ever had a storage unit and your address was bad or something else was bad, you probably got a call or a text or mail. We send 2 late bills before we even start the auction process. And then once the auction process begins, more telephone calls, 2 more letters and emails, of course, the legal ads, the online ads. We send additional letters and text, and many of us post signs at our facilities. We send out a lot of email blasts, not only to our customers, but to others who might attend to help try to recover, and do social media posts. The last thing we want to do is to sell someone's items, because they usually have a high emotional attachment to them. So selling their things is not what we're about. But being in control of our unit and being able to make money and pay our mortgage and pay our Georgia taxes. We do pay taxes, by the way, on the auction items here in the state of Georgia, which contributes to the overall budget. So for the 60 stores for that 2023 period, those were the numbers. And again, I would just have you know that after all the efforts that we make, last year's recovery rate dropped to 17%. Now Miss Megan Armstrong, a current board member, is going to talk to you about current processes.
Okay. My name's Megan. My husband and I own 2 facilities, one in Calhoun and the other one in Blue Ridge. And our biggest issue that we're having is our newspapers actually refuse to work with us. They don't like me particularly. There's only 2 of us. I do work a full-time job. Our newspapers are constantly losing our ads. No ad, no sale, and that means you have to move your lien process back 90 plus days. So I can't collect on my unit. The tenant has usually blocked my number at this point. I've offered to settle with them. I've had someone give me as low as $10. They owe me. It doesn't matter what they owe. They say, I can only give you $10. I say, that's fantastic. Let's schedule your move out. It sometimes works. It usually doesn't because I can't get a hold of them. But our newspaper currently will, you have to send them via email what your ad looks like. Then you have to call to verify it. Then you have to call 2 to 3 times to make sure that they have your payment. They usually don't. Half the time they still don't run our ads. So it's incredibly difficult to run our business from that respect. And from that, I'll pass it over to Jane.
All right.
Good afternoon. I'll make mine quick as possible as well. I appreciate y'all's time. Greatly appreciate y'all being here. My name is Jane Sauls. I'm a self-storage owner in Carroll County. I'm right there on the Douglas-Carroll County line. I also do management for a couple of other facilities. I'm a licensed real estate broker in 7 states, and our niche asset is self-storage. I speak on a national level and contribute numerous articles throughout the year. I wanted to address the couple of points of, first off, let's acknowledge that this whole relationship begins with that customer signing a contract and agreeing to make that payment. So at some point in time, we've got to get back to more of an accountability of standards just as a society. But in trying to make an attempt on collecting that after that signed agreement is completed, they get a friendly reminder on the first day of the month. On the 7th day of the month, they're touched again. They also are receiving late fees that they're aware of. On the 14th day of the month, they're touched again. The 21st day of the month, they're touched again. And this is all before even the auction process begins or anything else. Numerous texts, phone calls, emails. We aren't collecting, as Ann referred to. She's got numerous stores. I'm a small owner-operator. On one of the facilities that we manage there in Bowden, we had $6,600 in bad debt. I'm not to the $1 million status as Miss Ann here, but in my world, it's $1 million, okay? So that's 23% of that dollar amount is what we collected. At Little Vine, we've got a little bit better demographic there. We had $4,600 last year, and we collected 37%. So not only does it impact our cash flow from a timetable perspective of not being able to rent that unit when there's a delay in getting that tenant gone, the problem is not just that cash flow loss, but the actual value of it. And I wanted to be sure I shared that because you think about if the average facility in Georgia, roughly 40,000 square foot, just say all year long they have running 4 units in that lean process. If the average price is around $125 a unit, you're looking at about $500 a month, okay, in cash that they're not able to get. If you annualize that out, you're at $6,000. Here's where, $6,000 now in my world, again, that's a lot of money. That's going to be probably a third of my property taxes that I'm going to owe on that facility. But that $6,000, if I put a 6.5 cap rate on that, and you understand that self-storage is an investment income operating property, right? That's how it is valued, is off of that income stream. So if I cap that loss of income at a 6.5, that is a $92,308 loss in value. So you are talking about, to a small owner, if that is going to start impacting their facility and their operations as their balance sheet is impacted by $100,000. So again, we're here respectfully asking for consideration. We appreciate y'all's time, your efforts. It may seem like self-storage is not that big of a deal, but in our world it is. It is our livelihood. We are small business at its best.
Thank you.
All right, thank you. No questions from the committee. Thank you all. All right, we have Reagan Marsh from Troutman and the Georgia Press Association.
Mr. Chairman and members of the committee, thank you for the opportunity to speak today. I'm Reagan Marsh with Troutman Pepper here on behalf of the Georgia Press Association. Before I start into the bill, I'd like to just talk a little bit about current law, and I think it's something that should be pointed out. You know, current law allows a self-storage facility to seize someone's property and sell it. There are not many businesses that we allow to do that in this state. And if you think about who can do it, one example would be a landlord. If property is left behind for a delinquent tenant, they have some rights to go in and seize that property and sell it, but they've got to go before court. There's due process. We recognize that self-storage businesses are a unique business, and sometimes they have property in there that nobody wants. So we've given them the opportunity to not have to go through some of that due process to speed it up. Really, the only due process they have is the requirement to put out public notice. This bill eliminates that. If we eliminate public notice, a couple of things happens. Number one, consumers loses their last meaningful opportunity to learn that they are delinquent. Yes, they will get notices, and you've heard from a lot of good folks that have good business practices that send notice above and beyond what's required by the statute. Some people don't do that. Some people do the bare minimum, and without that public notice, again, that's an opportunity for someone to see that they owe this money and go and pay for it. In addition, there's others that would never be able to have notice that may have an interest in the property, and that could be, we heard this brought up earlier, there's a committee sub to include lien holders if there's a lien holder to require public notice. Well, there's others too. There might be a child of an incapacitated parent. It could be an heir to someone that has recently died. It could be a divorced spouse. And the question was asked, why are we just applying it to these lien holders? Well, keep in mind, too, that list of lien holders is a really short list of lien holders. There could be other types of lien holders that aren't included. I'll give you a real-world example of this. And I left a note, or there's a letter in your folders. And the letter is from a citizen of Columbia County who filed a lawsuit against a self-storage company. It was alluded to earlier in the presentation. But basically, grandparents moved from Mississippi to Columbia County. They put everything they own in a self-storage facility. That when they went to retrieve it, everything they owned was gone. And they received no public notice. And you'll see in that letter, they believe if public notice was put out, they would have noticed it. They would have been able to go over there and clear this up before their stuff disappeared. And I'll point out, because it's not in the letter, but it is in the lawsuit, you know, not to mention every stick of furniture they own, every bit of clothes they own, 6th generation of family photos, family Bible from 1883, marriage certificates, medical records, 30 years of tax returns. So what may seem like junk to some people in there, you know, is very valuable to other people. So I guess the bottom line from the Press Association is there's a very simple amendment that can fix this bill. And I know we've got a committee substitute. I don't have it, but I'm pretty sure I know what it says. And at line 118, there's an or. If we change the or to an and, we don't even need the other language in the committee sub, because by putting that in there, you're sending out public notice to everybody, not just that little limited group of lien holders, but all lien holders. You're also sending it out to the owner of the property and any heirs or anybody else. And that's actually less notice than what's required right now. So it is a compromise to some extent. Right now, the 2 is required. This will knock it down to 1, and that's our request. And make sure I'm right about this, Mr. Chairman.
Mr. Marsh, did your group oppose the bill in the House?
We talked with the bill sponsor. We talked with the other folks working on it, but we did not go to committee and talk about it. We attempted to, but unlike this committee, you got to give a little notice before you go talk in that committee. I didn't realize that. So. Okay. Do you want to continue? Just make sure the line number's right. Yeah, the line numbers are a little off from what I told you, but let's see. This looks to me like it still requires it to be published in the legal organ. I don't know if that was the intent here, but.
If it's a boat or car, one time in there, if it's a boat or car, but everything else, commercially reasonable means.
Yeah, our contention would be that the public notice should go to the public, not just folks this limited amount of lien holders.
All right, any questions from the committee, from Mr. Marsh? Senator Steele?
Thank you, Mr. Chairman. Mr. Marsh, can you and Representative Reeves make sure that those concerns have been addressed, or are you, it sounds like we're still trying to work through the sub to determine that.
Yes, sir, Mr. Chairman. After reading this, it does, Chairman Reeves, what he just told me, what this bill does, it says you only have to advertise in the legal organ if the property being sold is a motor vehicle, motorcycle, trailer, watercraft, or recreational vehicle.
Right.
And we would maintain that it still should be publicly advertised, even beyond just that very limited circumstance.
But the original House bill, to make sure I'm clear, was going to not require any legal notice.
None at all. That's correct.
Okay, and so the sub is going to.
Well, let me clarify that. You could do either or.
You could do either or, but you're not
which meant-
required.
right.
Or.
Correct. Yeah.
So but the sub would still require the legal organ when you have these potentially liened vehicles, right?
When there's a motor vehicle, motorcycle, trailer, watercraft, or recreational vehicle, and there could be other types of property with liens on them. I mean, think about people rent on furniture and stuff like that. So there's a lot of other things that probably leaves out of there, even if we're talking about liens.
But for the interest of the Georgia Press Association, it's the fees from the advertisements.
Well, I think, yeah, that's important without a doubt. But there's a fundamental belief that there should be public notice on things like this, and there should be due process. I mean, again, we're allowing someone to seize someone's property and sell it. What other businesses do we let do that?
Well, to be fair, there's contracts and these kind of things, right? It's a little bit different. I mean, it's just my opinion, but.
No, there are.
Any other questions from the committee? Senator Steele?
Sorry, thanks, Chairman. Mr. Marsh, can you jump to, I'm just trying to understand, 124?
Yes, sir.
Down to 129, where it's talking about the advertisement shall include, it's talking about that, and then it jumps to say the public sale to the highest bidder shall place not sooner than 15 days after publication, striking the words the first.
Yes.
So if they are placing the ad.
So what that's saying there, that's acknowledging that there's not two publications anymore, there's only one. But if you go back, it gives the option to make the publication on a website, which I'm assuming will likely be the public storage company's website.
What do we do in the event where counties don't have a legal organ?
There's no county that doesn't have a legal organ right now.
Okay.
But if that happened, there's in the code that deals with legal organs, it makes room for things like that. If a county happen to not have a legal organ.
Got it. Thank you, Chairman.
Any other questions for Mr. Marsh? All right.
Thank you, Mr. Chairman.
Do you want to close out, Mr. Reeves?
I do.
Representative Reeves?
Thank you, Chairman. One follow-up, the due process to the public and the check and balance here is one thing that remains in the statute. In addition to directly notifying your customer, you've got to advertise in a method that's producing 3 bidders. And the problem we have is 2 ads are being run and no bidders are showing up. So they're having to do additional ads. So there are some communities where the newspaper ads bring 3 bidders. And this bill says that's optional. If the ads are working, you can keep doing that. If you find a boat or car, you got to run an ad. But commercially reasonable means that produces 3 bidders, that is the due process, that's the check and balance, in addition to directly contacting your customer at the information they left.
Or you have a question, Leader Jones? Is it yours?
Getting clarification, because what this is doing is giving you the notification to the bidders to purchase it. The idea that this is not giving like due process to the person property, the intent of this is give notice to the bidders, right?
That's
who actually
right.
want to purchase the property.
We didn't change the current law at all about you are still required to notify your customer directly.
Okay.
So all those consumer protections stayed in place. All this is changing is the method of advertising your sale to produce 3 bidders.
To the bidders, correct. Thank you.
And there are some newspapers that generate 3 bidders, and that's still an option. Nothing prohibits newspaper ads, but what this says is commercially reasonable means, except if you find a car or something like that, you do still need to run an ad. And we did that, quite frankly, based on discussions as well as the lenders.
Senator Parent.
Thank you, Mr. Chairman. Just a couple questions. So would it be, out of curiosity, would it be in the best interest of storage facilities that sort of want to get a price for this stuff and clear it out to advertise in both anyway?
Well, the commercially reasonable means in a way that produces 3 bidders. That's the standard on the bill. Currently, it says you got to run 2 ads, and there's this timetable that's slower than 30 other states, and you've got to find 3 bidders. So what happens is, you know, they go there, they run their 2 ads, that fails, then they have to go advertise otherwise. So this is just providing some ways to get the 3 bidders quicker.
Well, I was thinking they would be married. Not this whole, you know, but I mean, it's, I guess,
Right.
maybe academic. But.
As you heard from them, this is a major loss, so this would reduce the loss in a way that's not producing more notice for the sale.
Great. And then one other question. I'm a little bit thrown off by this letter from Mr. Trupp in Evans. What happened in this incident?
Is that the Monster self-storage? All right, here's what I've gotten from the Monster self-storage case. And by the way, the lawyers who represented the customer in that case, I believe they represent the Newspaper Association, so they know this law well. They did a great job for their client. Their client got paid in that case because their rights were violated. But the customer apparently paid their bill. They weren't delinquent. And somebody at the self-storage made a mistake and said, you know, they're delinquent. They didn't contact the customer to say, hey, you're delinquent, we're about to sell your stuff. They didn't conduct a sale. They didn't place a newspaper ad. They made a mistake about payment, and they discarded the contents of a storage unit. And that storage facility got sued big time for conversion and torts and everything you could think of, and the plaintiff won in that case. And it's my understanding from talking to some folks in Augusta, it's not Monster Self-Storage anymore. They may have gotten chased out of business for that and other wrongdoing. So, yeah, that's a terrible case, but those folks didn't follow the current law. So this change we're asking for, it doesn't hamper anybody's rights. The people running, misusing or doing a bad job running Monster Self-Storage, they weren't following any law, and they paid for it.
Thank you.
All right, no further questions from the committee. I'm about to ask what the pleasure of the committee is. Keep in mind you have the new substitute, which is LC 620194S. What's the pleasure of the committee? Motion to pass, and Leader Jones, is it the new substitute?
That's correct.
620194S. Is there a second from Senator Rhett? Any discussion? All those in favor of the motion, please raise your hand. 1, 2, 3, 4. Opposed? 1. Motion carries. Senator still carrying the bill?
I will get back with you promptly, but
He
I
was.
will say
He
and
was.
I overlap, so we'll talk and make up, and I'll be back in
Redistricting's
touch.
coming soon.
Well, I will let you know who the Senate sponsor is before I turn that into rules. Thank you, Chairman.
Okay, I
Thank
think
you, members of the committee.
we have to know by the end of today, so if you can try to just text me.
Absolutely.
Thank you.
Thank you so much. Let's see what we can do to figure that out. You bet. Thanks a lot.
Are you in his Senate district? Do you live in his district?
No.
Oh, okay. Well, that solves that.
We live 5 minutes apart. That's right.
This could be your wedge issue. Self-storage.
We have more legislators within a half a mile than anywhere else in Georgia, I think. We're all in different districts.
All right. Representative Gullett, based on the sign-up sheet, I think you'll be a little bit quicker. Do you want to come up and do 447? I know my stack is all out of whack. Let me find the bill.
NSLC 481574S.
1574S, the version that passed the House, right?
That's correct.
All right, the floor is yours.
So what this bill does is there's a problem going on today with sophisticated criminal enterprises stealing gift cards. What they do is they steal batches of gift cards, capture the information off the gift cards, and then they put them back on the shelves for people to purchase. And once they purchase them, they drain the funds instantly. The retailers are out, the consumer is out, and the bad guys are in. And so what we're trying to do is resolve that. This isn't a small crime either. This is almost $1 billion last year for these thefts, and I imagine it'll be even greater this year. Again, it's organized, sophisticated criminal enterprises doing this, a lot of times overseas. And so what this does is closes the gap, and it ensures that the criminals can be properly charged and held accountable. Because today it's just a kind of a unique thing that's happening. Those gift cards don't have value today, so they're still in plastic. They're caught with duffel bags of plastic, but really they're stealing information, putting them back. And so when you purchase your gift card, they drain it and take your money. So I'm happy to answer your questions or go through the bill specifically, but that's really what it does.
We have Mr. Bryan and Mr. Cowart both signed to speak on the bill. Do you want to add anything at this time before we take questions?
Thank you, Mr. Chairman, and thank you to the sponsor for the bill, Ben Bryant. I am Vice President and Senior Division Counsel at Incom Payments, which is a global payments entity headquartered here in Atlanta. This is a bill we're very much in favor for. We work closely with law enforcement at the local, state, and federal level, and in terms of going after these fraudsters and helping to strengthen the gift card industry. And one of the things that we hear time and again is that the laws need to be updated to give prosecutors and law enforcement a better opportunity to go after these criminals. So happy to answer any questions if you all have them.
All right, any questions for Chairman Gullett or Mr. Bryant or Mr. Cowart, who gave me a thumbs up from the committee? All right, what's the pleasure of the committee? Motion to pass from Senator Steele. We got him back. Is there a second? Second from Leader Jones. All those in favor of the motion, please raise your hand. It's unanimous. Who's carrying the bill in the Senate?
Mr. Shaw, thank you.
He's voting for this one he's carrying.
Yeah, that's
so
right.
All right.
I'll teach Matt Reeves how to do it, right?
Yeah.
Thank you.
All right. Come on up, Chairman Werkheiser. We're going to go to House Bill 123. Easy as 1, 2, 3, right? Let's see. Have LC 481378. Is that right?
I have no idea. Yes, that's correct.
Okay.
Yes.
All right.
All right.
Floor is yours.
Okay. There are 27 states that have capital punishment, otherwise known as the death penalty. Georgia is an outlier because of two things that allows the state that brings these cases to execute those with intellectual disabilities. It's the only state that has a standard of beyond a reasonable doubt instead of a preponderance of evidence. So this would change that to a preponderance of evidence, again, aligning with the other 26 states. The other thing it does is, and there has been no opposition to that, the other thing that it would do is it would change to a pretrial hearing of whether the person is intellectually disabled or not. And here's why that matters. Currently in Georgia, and again, I believe it's the only state that does it this way, you hear 2 weeks of a gruesome trial, see photos you wish you could unsee, and then you're asked to decide whether the person is intellectually disabled or not, which is actually kind of backwards, because if you think about it, somebody's either intellectually disabled or they're not. And so this would have a hearing at the before a finder of fact, generally the court, and it would be a up or down decision. This person is intellectually disabled or they're not. And then you would have the trial portion of the case. And then at the end, it basically is removing the death penalty from being an option. And that's what the bill does in layman terms.
All right. You introduce yourself.
Certainly. Thank you, Mr. Chairman. I'm Michael Admirand. I'm a senior attorney at the Southern Center for Human Rights here in Atlanta. I'm trying to speak on behalf of the Capitol Defense Bar. I want to thank Chairman Werkheiser for his work on the bill. He's worked on this on the House side for a number of years now. And this is a good bill that I hope the committee will support. Before I dive into specifics, I just want to take a step back, because while this bill is very important, it's also very limited. According to the Georgia Department of Corrections, there have been over 150,000 people convicted of felonies and sentenced to prison over the last 10 years. 3,000 were for homicides. And in that same time period, there have been about 90 death notices, and only about 10 of those people claimed intellectual disability. So really, we're talking about 1 or 2 cases a year that this bill will affect. Now, it's important that we fix the problem for those cases, because the Supreme Court has said that people with intellectual disability face a special risk of wrongful execution. But we're talking about a tiny, tiny slice of Georgia's criminal justice system. And that's consistent with what happens in other states too, where despite lower standards and procedures similar to the ones that this bill would implement, claims of ID are raised in less than 10% of all death penalty cases nationwide. So I just want to keep that in mind as we talk through the impact of the bill. Now, as Chairman Werkheiser said, the first change to this bill would be to the standard of proof, lowering it from beyond a reasonable doubt to preponderance of the evidence. And although I'm happy to answer questions, I won't spend a lot of time on that bill because the prosecutors have not voiced opposition to that this year. And it's an important change, but it's not enough to fix the problem. The procedural change is critical to the success of this bill. And I'm not trying to be cute about it, but the way I think about it is, if the clock's running out and you're down by a touchdown, kicking a field goal is not going to help you very much. The score will look a little better, but the game's still not tied. And we need to change the process if we want a tie game. So under current law, the jury makes 2 decisions at the same time: whether the person's guilty, whether the person has ID. This bill separates those 2 decisions. And that's important because the U.S. Supreme Court has said so. A few years ago, they considered how Texas handled intellectual disability. And one of the things Texas did was ask jurors to look to the facts of the crime and consider whether the crime showed evidence of planning or forethought, and basically whether you think someone with ID would be able to commit the crime. And the Supreme Court said, no, you can't do that. The facts of the crime, the question of ID, those are separate questions. Putting them together like this, and here I'll quote, creates an unacceptable risk that persons with intellectual disability might be executed. In other words, you need to separate those 2 decisions because then you make them both more accurate and you lower the risk that someone with ID will be executed. And this makes sense. The guilt phase of a capital trial should be focused on one question: whether the defendant is guilty. ID is a sentencing question, not a guilt question. With respect to the optional pretrial hearing, it's been suggested in the House that, excuse me, not by House members, but by testimony in opposition to the bill, that the pretrial hearing would grind capital cases to a halt, lead to endless litigation, and that's not the case. First of all, it's optional. Lines 19 through 22 of the bill make clear the state can object to it, the court can decline to hold it. It's only mandatory if the state agrees to it. And there might be cases where they want to agree to it. Maybe they want to get a preview of the defense evidence. Maybe they want to see how their own expert might testify. Now, if there is a pretrial hearing, it's not going to slow anything down. Capital cases have lots of pretrial hearings on lots of different issues: jury panels, forensic evidence, witness statements, you name it. This is the one issue where there isn't even an option for a pretrial hearing. And that doesn't make sense, because people with ID are entitled to more protection, yet we're providing them with less. And something Chairman Tyler Paul Smith said on the floor resonated too. It's also not efficient, because when the pretrial hearing happens, it can simplify the case and save the state the expense of a capital trial and the appeals that would inevitably follow. Now, regarding those appeals, someone may say that this is going to lead to endless appeals, and I just want to clarify something about the bill. Lines 33 to 34 authorize a pretrial appeal if there's a pretrial hearing on the issue. And we added that at the request of the prosecutors when a similar bill was introduced last year. So the only new appeal in this bill is for the state. All the other appeals are going to happen no matter what. It was also suggested that everyone on death row is going to get resentenced because of this bill. So I want to be very clear, and this is painful to say as someone who represents people on death row. This bill will not apply to anybody on death row. Line 108 explicitly says that the bill applies only to cases that go to trial after July 1st, 2025. The Georgia Supreme Court has also already held that procedural changes to this procedure would not be retroactive. Now, maybe someone tries to file something and argue that it should apply, but they're going to lose because the text of this bill, the existing law, is clear. And the last thing I'll say before I take any questions you have, some people might come up behind me and say, we've executed people with intellectual disability before. Others might say we never have. And I think we could debate that until the end of time. But the question for this committee isn't whether we have or haven't. It's whether there's too high a risk that we will. And this bill will ensure that we don't. So thank you for your time and for your consideration. I welcome your questions.
So in our work leading up to the day, one thing that was pointed out to me, looking at line 125,
yes,
the way this is written, it says court shall sentence defendant to imprisonment for life. Without adding the option of life without parole, does the bill also make it where someone that has an intellectual disability also could not receive a sentence that's life without parole?
That's what current law is. If you look at it, it's not in this copy, but current law only provides for imprisonment for life. We haven't changed current law. And I think our position is we would never support adding life without parole. At the same time, if the committee were to add it, we would just ask that it be or life without parole as opposed to a mandatory life without parole sentence.
Right. Okay, that'd be the end of line 125, or life without parole.
That's correct.
Okay. Do you have other questions, Senator Steele?
Thank you, Chairman. If I could direct you to line 108, you just referenced after July 1st, 2025. Why would we wait any longer than we had to upon the signing of this into law? Why wouldn't it just be upon signature of the governor, so that if there was anyone in that gap, we weren't waiting longer? It just seems like this is such an important bill that I understand the reason to put a date on it, but if the governor were to sign it tomorrow, we may save a life. And I'm just asking the question for understanding.
Love that amendment.
Yeah,
So
we have
we're
no
gonna make
objection to
change
that
anyway.
amendment.
Yeah. Thank you.
Ledge Council, is that something that's...
Is there any constitutional, Mr. Hennessy?
At the moment, I cannot think of any. However, I'll double check on that one, but...
I mean, we do a lot of bills that say upon signature of the governor.
I can say since it is applying to actions that start after it, I cannot see one right now.
Okay.
Thank you.
Is it Leader Jones? I'm still trying to figure out your mic numbers. Or is Senator Rhett, sorry.
Thank you, Mr. Chairman. This bill passed unanimously, right? No one voted against it in the House?
Correct.
Okay.
Any other questions for the author from the committee? Are there others to speak on the bill? Thank you.
Thank you.
We'll give you a chance to close out at the end too. Maisie Lynn Girton from Gactel. Welcome, Mr. Leader, down to our last bill.
We'll be back in this law class.
Yeah, we learn a lot every time.
Good evening. Thank you for hearing.
Never been called professor before.
Sorry. I thought you paused sometime. Sorry. Maisie Lynn Girton. I'm the executive director at the Georgia Association of Criminal Defense Lawyers. I come bringing Gactel's support of House Bill 123 as drafted. As was mentioned just a moment ago, this version was unanimously passed not only on the House floor, but on the majority leader's motion out of committee. And it received a standing ovation upon passage on the floor. In the 2021 Young case, the Georgia Supreme Court signaled a need to address Georgia's standard of proof when determining whether a person facing a death penalty prosecution for murder is a person living with intellectual disability. This signal came because we are, as you've heard, an outlier nationwide. Georgia is the only state that requires proof beyond a reasonable doubt that a person is living with intellectual disability. It is also an outlier in the procedure used to make this determination. By asking trial jurors to decide whether a person is living with intellectual disability at the same time they are determining whether she committed a very terrible murder, this conflation of these issues is not only confusing, it's prejudicial, and it's just as burdened as the standard of proof is, as pointed out in the Young case. As Mr. Admiran mentioned, it would be a half measure to be concerned about the standard of proof and not also about the procedure, which is why House Bill 123 brings substantive change to both for the very few future death penalty cases when a viable intellectual disability claim would exist. House Bill 123 will make certain we take the small number of intellectual disability claims seriously, giving juries the time they need to make certain that Georgia is not in the business of executing intellectually disabled citizens. We urge your support of the passage of House Bill 123. Chairman, I heard your concern and question about the possibility of adding life without parole sentences to this bill. Right now in Georgia, a life sentence in Georgia must be served for a minimum of 30 years before a person can even be considered for parole. And that's considered, not necessarily released. That timeline was set back in 2006. Before 2006, a person would have to be in prison for 14 years before they could be considered for release from prison on parole on a life sentence. Obviously, we haven't seen 30 years pass since 2006, so we don't know what the average sentence is going to be for someone who receives a life sentence under this 30-year minimum. But we know that before that time, 14-year sentence, people that were under the 14-year sentence rubric were serving many more years than that. I don't know the official statistics, but I can tell you I've represented a person seeking parole who was also under that 14-year rubric when he was convicted, and he served 26 years before he was considered to be released on parole. You'll hear, I believe, from one of my colleagues today of a similar situation for Vanessa Marshall, who was also sentenced during that 14-year time frame and has now served 26 years and remains in our Georgia prison system. I say all that to say that a life sentence is meaningful and it is long. And it is in a Department of Corrections that the Department of Justice has recently issued a report on that was scathing for the way that people are treated when they are living in those facilities. Gactel does not support increasing opportunities for life without parole sentences to be applied, especially for people with diminished culpability, which is what a person living with intellectual disability has been determined to be by the Supreme Court of the United States. However, the import of the larger policy measures in House Bill 123 prevent Gactel from opposing its passage should the committee decide it's suitable to expose a person living with intellectual disability to a sentence of life without parole. We support the bill as written and believe it represents a step forward for Georgia. We acknowledge that the bill is good policy and hope that you will pass it today as you read it in your folders. Thank you.
All right, thank you, Ms. Girton. Any questions for Ms. Girton? Thank you.
Thank you.
Next, we have Russell Gabriel, also with Gactel. Good evening.
Thank you. Thank you, Chairman. Esteemed members of the committee. I appreciate the opportunity to speak with you. I've been a criminal defense lawyer in Georgia since 1988. For a period of time, I was the head of the public defender office in Athens, and that was prior to the existence of the state public defender system. And so we handled death cases in our office at that time. So my experience with the death penalty is as a trial lawyer, where I've negotiated a few cases and also tried a few cases where the death penalty was on the table. One of those cases that I tried was a case where the client, the defendant, had a very well-established record that meant she was intellectually disabled. Right? So, and we went to trial on that case. And the jury found, even under the beyond a reasonable doubt standard, that she met the standard. I believe in the hearing in front of the House, it was mentioned by the prosecution, and I'm sorry, I don't know the name of the, Barksdale was your colleague, I believe, said that no one had ever been found to meet the standard beyond a reasonable doubt and have an intellectual disability. And that just, it's wrong, because I had that case, and that is what happened. That's not a win, right? Because she was also found not guilty of murder. She was found guilty of involuntary manslaughter. But she was found guilty of felony murder. Right? So she was one of those people who was sentenced, that Mason just mentioned, who was sentenced to life with parole, and the parole board was forbidden from exercising, its authority until she had served 14 years in prison. Right? She was arrested in 98. She was convicted in 99. She's still in prison now. Right? So, to the extent when we talk about parole and there's some number on it, like they have to serve at least 14, that's true, but that does not mean that the parole board is letting people out at that point. Under current law, it's 30 years. You have to serve at least 3 decades before the parole board can exercise authority at all. And that authority is just the authority to make a decision. There is no other legal apparatus in Georgia to re-sentence a person at that point in time. The only way that that's the person's current circumstances, which is someone who was convicted 30 years ago or more, and then has had 30 years of behavior in prison, which becomes part of their behavioral record. People want to know what happened. How's this person been? How have they acted? The parole board's the only vehicle for that. So that an LWOP sentence, life without parole, means there is no legal vehicle for someone to be released. Okay. One of the things I wanted to mention was, and it's drawn from my experience, is how sort of messy a trial is, where you've got both intellectual disability as one of the issues that a jury has to consider and that the defense has to establish, and you also have the murder case, the homicide case, that is being tried all at the same time. And the rhythm of these things is just so very different. The trials are not sporting events, but certainly not this kind of trial. But not unlike sporting events, they do have an ebb and flow. Right? There are times when the emotions are high in a trial, and there are times when not so much. There's times when things are very, very interesting and the jury is just leaning forward to listen to the next word, and there are times when that's not the case. Okay? So when you have a homicide case and an intellectual disability case at the same time, which one do you think gets the attention? The facts of a homicide, whatever they may be, are an interesting narrative. The facts of intellectual disability are somewhat technical. They are records, they are IQ tests, especially. It's just not the same kind of evidence. It doesn't have the same pull. It doesn't the evidence in itself doesn't draw people to pay the attention in the same way. It's not as deep a current as the homicide facts are, regardless of what that homicide is. Not that this is the way it should be, but this is the way things are. Some things are just more interesting, right? So that's one of the reasons that splitting these out so that you have a separate trial on intellectual disability from the trial on guilt or innocence is so important to accuracy, to the accuracy of the proceeding, right? Lowering the standard of proof similarly helps, because there are issues in intellectual disability cases that other cases don't necessarily have. And I wanted to very briefly, the words of the United States Supreme Court in Atkins versus Virginia. That's the case where they held that persons with intellectual disability may not be constitutionally given the death penalty. And they're discussing the difficulty of having a trial where the defendant, where one of the parties has intellectual disability. And they say this: those mentally retarded, in the language of the day, those mentally retarded persons who meet the law's requirement for criminal responsibility should be tried and punished when they commit crimes. Because of their disabilities in an area of reasoning, judgment, and control, however...
Mr. Gabriel, I don't want to cut you off, but I was just told we do have a hard stop at 6. There are a number of people to speak on the bill.
Okay.
So if you can...
This is...
Yeah, just wrap it. I don't want to have to hold the bill another week.
The court says they do not act to the level of moral responsibility that characterizes the most serious adult criminal conduct. And moreover, their impairment can jeopardize the reliability and fairness of capital proceedings against mentally retarded defendants. Mentally retarded defendants may be less able to give meaningful assistance to counsel, are typically poor witnesses, and their demeanor may create an unwarranted impression of lack of remorse for the crime. So there's built-in sort of accuracy issues with respect to litigating the question of intellectual disability. In the case that we had, the record was very clear, and it was available to us. We had records from 3rd grade, 6th grade, 9th grade of Vanessa Marshall, where the state's own system was finding that she was intellectually disabled, right? There was subsequent testing as well. All of it was consistent. And nevertheless, the state sought the death penalty in that case, rather than conceding intellectual disability and going on ahead with a trial that wasn't a death case. I thank you for your time.
Thank you. All right. Next, we have Charlotte Dinsmore. Got really loud.
I am not
No.
Charlotte Dinsmore.
Or Elizabeth Appling?
No. She asked me, my name is Elizabeth Apley. Charlotte asked me to please state for the record that the Georgia Council on Developmental Disabilities supports the legislation. And I believe I am the next witness, Mr. Chairman.
You are. Now we have Miss Elizabeth
There we
Apley.
go. That's right. I'm playing myself today. On behalf of the Georgians for alternatives to the death penalty, we just want to thank the chairman for hearing us today, and the committee. Thank Chairman Werkheiser for bringing this bill, for the passion and compassion he has shown in working so hard to bring this issue forward, and we urge your favorable consideration.
Thank you. Next, we have Frank Mulcahy from the Catholic Association, Archdiocese of Atlanta, not association. I'm so used to associations. And also Miss Maggie, I can't read your last.
Rousseau.
Okay.
Mr. Chairman, I am Frank Mulcahy with the Georgia Catholic Conference. I'm going to be very short and just say that we support this bill. We have worked with the author for several years trying to get this bill passed. We think all of it is worth passage. I would like to spend our time listening to Maggie Rousseau. She has both professional and personal experience on what it is to be intellectually disabled. And so, Maggie.
Thank you, Mr. Chairman and committee members. I've spoken before this committee in past years, for those of you who don't know me, I'm the director of the Disabilities Ministry for the Archdiocese of Atlanta. My son was born and diagnosed with an intellectual disability that was a result of a genetic disorder. And after he passed away, I got a master's to teach special education and worked both in Gwinnett County and down in Effingham County. And that was really an education for me as to the disparities of what's available to people in rural areas when it comes to just advocacy and support. So I just very briefly, in past years, it's been hard to explain to the different committees what intellectual disability is. And although I'm not an attorney and these are not legal terms, basically intellectual disability is an injury to the brain that does not get better. So you cannot, you can help someone who can be educated and supported and have the right accommodations to live successfully. But often without those accommodations, that person is going to still have behaviors that are a result of that intellectual disability. And given, again, over the years, how difficult it's been to explain intellectual disability, I can't imagine a jury having to decide that, because you would never have a jury that's got the right psychologists and sociologists or teachers or individuals who really understand what it is. And I'm just going to add, I met with a family this week from Western Georgia whose daughter is already declared incompetent. She was convicted of a crime. Her diagnosis is intellectual disability. She was convicted of a crime. She's on parole, and she's committed another crime because she hasn't qualified for a 24-hour waiver, so she doesn't have supervision. So the passage of this bill really would protect people like this young lady. And again, as previous testimony mentioned, we're not talking about many cases. We're talking about a few, but as far as we're concerned, every life is valuable, and we encourage you to support the bill, and I'm happy to take any questions.
Thank you. No questions for the committee. Thank you.
Okay.
Great.
Thank you
Thank
both.
you very much.
All right, last person signed to speak, Wright Barksdale. Good evening.
Good evening. My name is Bright Barksdale. I'm the district attorney for the Okmulgee Judicial Circuit. I'm a district attorney that's in a unique position because I've tried 2 death cases in the last 4.5 years. I've also withdrawn death notices on 2 cases that I filed. We're not here to play football games. We're not here to play sporting events. The district attorneys across the state, when we file a death notice, it is the worst of the worst type cases. The statistics prove that because in 1999, there were 130 people on death row in the state, and there's just over 30 people on death row right now. I'll say that we have agreed to support the standard of proof change. So I want that to be clear. I testified in front of the House and made it known that we opposed all other procedural changes. However, as this bill has made its way through the process, I have a pretty confident belief that some version of this bill is going to be passed. So I want to spend the rest of my time talking about the best bill possible. And I'll say it this way. Look, if you want to do away with the death penalty, that's your job. I'm the district attorney, and I have a very traditional view of my job, which is to follow the law. But as this bill is currently written, it will make it very difficult for district attorneys to seek a death sentence, and it will still be on the books. So when somebody kills 10 people, 15 people, and those are rare cases. We have to file. We feel the pressure from our community to file. So what I want to say is this. We are fine with a pretrial hearing. We are fine with you actually changing this bill and making it where we don't have a say in it as the district attorney. Change it to where if the defense wants a pretrial hearing, they get it. The way the current bill is currently written, if a judge were to rule against the defense, they have a right to immediate review. What we don't want is to have 3 phases in our death penalty law. It's already long enough, it's hard enough, and as it's currently written with the 2 phases, which is guilty, not guilty, and then aggravation, mitigation, defense counsel would still have the ability to argue that something less than death is appropriate. What I'm trying to get to you is that if you want the death penalty in this state, you cannot package it up as this bill is currently written. There's no way that prosecutors are going to be able to seek the death penalty and it be effective. When we talk about a level playing field, that's what some of the folks talked about, then let's do a level playing field. And if you're going to do a pretrial hearing, okay, here's the thing. In my experience in death penalty work, between phase 1 and phase 2, that's when I got 8 banker boxes of information that was critical to a defendant's intellectual disability. There was no way on that short time period that I could evaluate whether or not somebody truly was intellectually disabled. 2 weeks ago, my office, on a death case, a guy stabbed somebody 60 times and set him on fire at Baldwin State Prison and watched. I withdrew the death notice and ultimately agreed that he was mental health. We could have done that 3 years ago, but 5 days before the trial was to take place, we received all the information. If we care about intellectual disability, if we care about mental health, if we care about getting the right answer, then put in this bill that defense attorneys are to give us that information 60 days before a pretrial hearing or 60 days before the trial. DAs are not seeking the death penalty. The numbers support that. The last thing I want to do is sentence somebody to death that's intellectually disabled. The last thing I want to do is sentence somebody that's mental health. That's the last thing I want to do. I'm here to do the best job I can as a prosecutor and keep our community safe. But what I've experienced is hide the ball. And we're hiding the ball with people's life. So we're fine with the standard of proof being changed. We're fine with having a pretrial hearing. We're fine with them having an immediate review. We're fine with taking prosecutors out of the ability to even object to the pretrial hearing. But as to the trial itself, leave that in place. And I would ask that in this bill, you have the opportunity to allow prosecutors at least 2 months to review the information, because I, as somebody who has sought 2 death penalty cases, I've withdrawn on 2 when provided the information. Please help me and other prosecutors get it right. If that's what the intent of this bill is, help us get it right. But waiting till 5 days before trial or 5 days before a hearing to give us somebody's kindergarten records, first grade, second grade, IQ scores, all of that information, that is a lot of information to go through. I'll be happy to answer any questions you have.
You do have questions, Leader Hatchett.
All right, thank you, Mr. Chairman. So I was trying to follow along. Essentially, what you're asking us to do is to make some type of amendment that would allow you to get, I guess, for them to disclose what they have to support their position of an intellectual disability at what phase?
If you're going to have a pretrial hearing, there's nothing in this current statute that prevents them from having a pretrial hearing and my office never getting any of the information or the witnesses.
Okay.
And so if somebody is truly ID or mental health, why wouldn't you want the prosecutor to get your expert reports? Why wouldn't you want to see those school records? Why wouldn't you want them to see that so that we can look at it and go, my goodness, you're right. But that's not been my experience at all.
And so, if I can, Mr. Chairman.
Go ahead.
So right now I know the ID hearing occurs post-trial, correct?
As the current bill is written, yes.
Well, as the current law is now, not this
No,
bill moves it up to the front.
There's no ID hearing at Georgia's current law. There's not an intellectual disability hearing.
So you go through the entire hearing, or excuse me, you would go through an entire trial.
Mhm.
You get the death penalty, or it's someone's sentenced to the death penalty. Then you have an ID hearing after that, the
No.
way it is now.
No.
All right, explain it to me.
Are you
Explain it to
saying
me.
when you say
I'm a civil attorney, so I don't practice.
No, it's fine. Are you asking me what is the bill proposing?
No, I'm saying what is right now. Walk me through exactly how it goes.
The death penalty currently in the state of Georgia is 2 phases. The guilty, not guilty phase. In that phase, a jury, if you said they were ID, the options on the verdict form would read guilty, guilty but intellectually disabled, guilty but mentally ill, or guilty.
Okay.
And maybe 5. But
you may be about to ask this, in the current process, is there any requirement of getting the information that would be presented to the jury from the defense at that jury trial phase?
5 days before trial.
Okay.
So, but essentially what we're doing here with this bill is if someone is going to claim that they're intellectually disabled or have an intellectual disability, this would be a pre-trial hearing, and that way it ultimately could save time and resources, help the court out. But what your argument is, and what I think I would support this amendment, is that if someone is going to request a pretrial hearing, that they at least provide the prosecutor's office with information that they're going to use to support their position 60 days prior?
Correct.
Okay.
I'm going to tell you something. Most of us do not have the staff in district attorney's offices to adequately handle a death case. Give us an off-ramp. Give us an off-ramp.
It's just transparency.
I've got a bunch of, if I have 3 children killed, God forbid, all right, and we file a death notice, because our community right now, I'm telling you, my community is going to want me in Middle Georgia to file a death notice if 3 children are murdered. But if defense counsel gives me the records and shows me that this guy's in special ed and has been since he was in 1st grade and he can't read and write, and that's compelling evidence and gives prosecutors the ability to make a different decision.
Just because of us scheduling back and forth, the higher ed committee is now going to be moved in 3:30 next door. Okay. So if you're here for the higher ed committee, you're in the wrong place. I don't think anybody walked in, but for the record, if there is a record. Back to that question, you asked for 60 days notice. So the current law is 5 days notice prior to the jury trial. Mm-hmm. Do you need the full 60? Do you need more for the pretrial
What we're talking
process?
About, and it's been acknowledged by people that are supporting this current bill, this is very complex information, and it's information that the capital defenders spin, and they'll tell you, Judge, this case cannot be tried in 2 years. It's going to take 4 years before we can get ready. So we're talking about years worth of work on a capital defender's part to get somebody's school records, ID, get evaluated, get all that information. I think 60 days is reasonable. If you tell me, right, we're only going to give you a month, that's at least enough time for us to consume that information in a way that we can make an educated decision. But right now, as this is written, if you have this pretrial hearing, you're not going to get a witness list. You're not going to get any discovery. We just show up flat-footed and get hit with whatever we get hit with.
Senator Steele.
Thank you, Chairman. You make some great points with this, and we want to be able to give our DAs the best tools possible. We don't always have the best DAs, and what you're talking about is I think what we would want every district attorney to aspire to in the way you examine evidence. But when we look at some of our other counties that have thousands of cases backlogged and they're not looking at the file until the day before, maybe not on murders, right, but on certainly other very difficult, complicated cases. Aiming for the lowest common denominator, let's assume that you're kind of at the peak of what we would want our DAs, the way that they examine evidence. How do we write this? How do we amend this for the lowest common denominator of a DA, assuming that they're not operating at the level that you are?
One, what I would tell you is that there's been 5 death sentences since 2010. There's a little over 20 pending death penalty cases across the state from what I could, don't hold me to that, but thereabout. I asked all the DAs, wouldn't you want to give us, whether you're the best DA in the world or the worst, wouldn't you want to give DAs the opportunity to review this information? Wouldn't you want them to have the opportunity to make an informed decision? What I didn't tell you about the guy from Baldwin that we just handled, he shot his girlfriend in Rockdale County about 5 times in the head. And he was in Baldwin State on a probation vacation. And then I watched what he did to the fellow inmate. So it's this balancing act that we're trying to do as a criminal justice system of protecting the public, protecting other inmates, and also ensuring that as to a defendant, in the rare situation where a death case is filed, that all parties have the necessary information to make the right decision. I believe DAs already have demonstrated almost 2 decades of behavior of reducing the number of times that they file. We don't have the resources, we don't have the manpower, and quite frankly, you were asking about DAs with backlogs and that kind of thing. Those people you speak of aren't going to be filing a death sentence anyway.
Well, some do, and they lose. And we have counties, we have DAs with thousands of cases on backlog, and we have DAs that have, on simple misdemeanors, a win-loss ratio of less than 50%. Do you have a copy of the bill in front of you?
I do.
Line 17. The accused may file a pretrial notice of intent to raise a claim of intellectual disability. What you're talking about is you don't have enough time to prepare. So if that is instead of a may file, that they shall file within a certain period of time prior to pretrial notice of intent, does that alleviate your concerns about preparation for a case?
No, it does not. Because if you're talking about the records that we've been given in very short notice, they're typically records that we struggle to get. They can give us a notice, and it's going to say, hey, we're going to claim intellectual disability for our client, but that's all it's going to say. It's not going to give us the information to review to be able to make an informed decision.
So how much time would you need to prepare for that, and what kind of notice would they need to give?
I'm fine with them giving us a notice, but 60 days before a hearing or the trial, that they give us the information, which is going to be banker boxes worth of information.
Chairman, is that something that, I think it seems too complicated for an amendment. I'm just trying to figure out a way to.
I'm trying to keep it in order, but the author is going to want to pine on that. I don't know what he's going to say. He may say it's great. He may tell us a reason to reconsider. I don't know what he's going to say. So I don't know how complicated it is yet. It'd be my intent. It's a very important bill. But if you look at a calendar, if it gets out next Wednesday versus today, yeah, then it's not the end of the world. The bill is still in a great place to move. There's great support for this bill that's been expressed all around that building across the street. So I want to make sure we get it right. So if we can do it now, that's great. But if we can't, then it's my obligation to give us a few more days to get it right. That's a long answer, but that's how I feel.
That's what I need to thank you, Chairman.
One thing I just wanted to say, I want to say this, and I hope y'all don't know me, but I mean this from the bottom of my heart, okay? I'm not a fan of this bill. I'm not. But if this is going to be the law of the state of Georgia, and I'm going to follow it, then I want to make the best version of it possible. And so I'm here telling you that I'm conceding to a number of things. If you listen, I'm trying to meet halfway, but I'm also trying to make sure that district attorneys, if you still want the death penalty here in the state of Georgia, that they have a fair opportunity to seek that in the less than 1% of the cases where there's a file for where they filed for death. Okay, I understand what we're talking about here, and quite frankly, I don't know anybody, district attorneys included, that enjoy filing death penalty cases or working them at all. So, bottom line, whatever you guys decide, I'm going to follow, and I'm going to wake up every single day and try to make this community that we have, this state, the best that we can have it, and the safest place for your kids, your grandkids, and my family as well.
Other questions at this time? All right, let's bring, thank you. Chairman Werkheiser, come on back up.
So, Senator Steele, I've been doing this battle for 3 years today, and I just confirmed to make sure I didn't miss something. This is the first time I've heard we need 60 days. And this is what's been going on for 3 years. It's been playing whack-a-mole. We don't like it for this reason. We don't like it for that. If they want a 60-day bill, let them drop that next year. But here's the problem. Let me tell you what happened on August 12th. Well, let me back up to July 17th and then to March of last year. We've had over 3.5 hours hearings on this bill, very thorough in the House Judiciary. They could have been addressed. The first hearing, organization comes up and talks against the bill, never came to me because there's not a person in this building who has a more open door policy when it comes to a bill. In fact, as Chairman of Industry and Labor, anybody can tell you if you have a bill and you come to me with an idea, the very first question I'm going to ask you is, who doesn't like your bill? Run toward them. Don't hang around with the people that like your bill. Go see them, work with them. That has not happened. On August 12th, well, on July 17th, we set a meeting up for August 12th with PAC, the sheriffs, DAs. He was part of that. I don't live right down the road, so drove 4 hours to Marietta so I could backtrack since it was a morning meeting. The very next morning, I was on my way from Marietta, and the DA called Wendy. You can cross-examine her, and said, tell Chairman Werkheiser there's no reason to come. There's no negotiation. We don't like the bill. So there was 7 hours, 2 days. Do I get to claim a per diem if I don't accomplish anything? It's just, it's frustrating. And again, it's been 3 hours before this, about an hour today. I would ask y'all to pass the bill as it is. If they want to make changes to the bill, I would have supported a 60-day. I would have supported almost everything that they've brought to me. But bring it to me. Don't show up when 5 minutes before there's time to have a vote and say, oh yeah, this is a problem, when it hasn't been brought to me. That's been very frustrating.
You do have a question from the committee, Senator Rett.
No, I was just going to say at the proper time, I'm ready to make a motion.
Any other questions for the author of the bill? Senator Steele.
Thank you, Chairman. As previously discussed in your opening comment, the only amendment I would ask the author to maybe consider would be on lines 108 and 122 to change from after July 1st, 2025 to just say upon signature of the governor. That way, if there is anyone in the gap, that we don't miss that.
So we would know if there was someone. The only, I'd like a claim bill just because had this in Judiciary yesterday with Senator Brass. He asked for a clean bill just because you know what can happen in the last 3 days of stuff. But I love the amendment. I'm not opposed to it. That's up to the committee. I mean, I would love a clean bill just because y'all know what can happen in the next 4 days.
Chairman Workhard, the challenge is there also is a
scribbler
typo
error. Okay.
that's
so,
wrong. It's got to be changed either way.
Okay, so that's fine. Let's do both. Yes.
Is Leader Hatchett, and I'll give some thoughts too. Go ahead.
And like I said, I practice civil law, but I know when we have pretrial hearings or we have motions, we have discovery, and you may be able to speak on this. If a pretrial hearing is requested by the defendant, and I know this is unique because I see here that the burden of proof is on the defendant at the
Correct.
pretrial hearing, which is unusual for a
Correct.
defendant to have the burden of proof. It's
Correct.
usually the opposite, but I understand why. Does the fact that they have the burden of proof and that they are the ones that are requesting the hearing, what are the rules now as far as disclosure goes with a party that that has to carry the burden of proof? I mean, I hear the prosecutor back there that wants 60 days, and I don't know if that was something he brought up or that was suggested up here, but there's got to be some type of evidentiary rule
I get
right
that,
now, right?
But bring it to me before today.
No, I'm asking the question.
No. Okay. Can I dial a friend?
Yeah.
Are you young enough, old enough to know what that means?
I do. Yeah.
Mr. Admiran, right? Yeah. If you want to come back up, because I'm curious of that
Regis
too.
Philbin. Yeah.
And look, I'd say the same thing if I was you. I've been frustrated with my bills before too, but it's my job too to make sure that and I know you know that, to make sure we get it right. And if we need to make this change, I'd rather us do it now.
And I forgot about the scribbler's error. Yeah.
We have the time to do it, but I also don't want to do it on the fly.
I understand,
I'd
and I don't
rather
want to
do
be
it.
haphazard, but like I said, my door's been open.
You have a right to say that. I understand. But for us, we get this one quick
know.
window. It's easy for us. It's
And I
harder when you've
want to be
worked on.
right.
How many you've worked on for 3 years now? I know you
Yeah.
have.
And I'll carry that bill next year if they want me to. I mean, he's not the enemy. I just, come to me.
I understand.
So I try to, first of all, under current law, if someone's raising a claim of intellectual disability, the state will have the opportunity and the right to have their own doctor examine him to give their expert's own opinion. So there's already some disclosure of evidence and expert opinions under current law. It's not in the text of this bill because this concern hasn't been raised before. I think with respect, and I have a lot of respect for what District Attorney Barksdale does, and I know he has a large circuit. The cases that he's talking about, the late disclosure of evidence, that's not intellectual disability evidence. That's penalty phase evidence about other mitigation. If there's a bill that he wants to bring regarding penalty phase discovery, that's a completely separate and larger issue. This is a small bill about intellectual disability claims, and already under current law for this type of claim, there's going to be a discovery process. And to the extent the law is unclear about that, courts will make sure that the state has the right to have their own expert examine him, much like they would in a competency proceeding. So we don't think that additional discovery language is necessary. To the extent there needs to be language, I imagine there is a quick line or two we could add to clarify that in claims of intellectual disability, the court shall order each party to exchange expert opinions 30 days before any determination is made. Maybe a line like that might address those concerns.
You have a question from Leader Hatch.
Please.
And that was going to be my question is, I don't want to do something that's not necessary. And excuse my ignorance on criminal law, but in criminal procedure prior to a pretrial hearing, I know this is going to be new and unique, but there's got to be some type of discovery right now, right?
There is discovery right now.
But is it limited just to experts, or?
It's for claims of intellectual disability, it would be any evidence that they plan right now, because it's occurring in the guilt phase, and any evidence that they intend to rely upon. Expert opinions, the basis for those opinions has to be disclosed under current discovery obligations,
And if
in part to ensure that the state has the right to have their own experts examine him.
And Mr. Chairman, if I may, is it up to the judge how, I guess, the shot clock outside of the hearing, when you have to disclose that as far as number of days? Is it 30 days, 60 days?
I think the current statute, under current discovery law, it's no later than 10 days before trial, or at such time as the court deems appropriate.
Okay. 10 days before trial would not capture a pretrial hearing necessarily.
No, and so I think if the court, right now under this bill, a pretrial hearing is optional. I think a judge is only going to grant one if he thinks that she thinks that there's reason to believe that the person might be intellectually disabled. So the defendant, as you pointed out, Leader Hatchett, with the burden of proof, would have to attach some type of proffer about what they're going to introduce at a potential pretrial hearing. And I think courts in their discretion would fashion a discovery schedule for that specific hearing, much like they do for any other pretrial hearing regarding jury panels or other expert testimony that might be introduced.
Okay. Thank you.
Thank you.
Any other questions from the committee? All right, well, I'll be the bad guy. I'm hoping I'm still carrying the bill in the Senate. I'm committed to you to get this bill done, but let's make sure we get it right. So what we'll do is put this back on for next Wednesday. In the meantime, let's get the scrivener error fixed, which should be easy.
So that Senator Steele tried to elevate you. His upon signature as the governor.
And then I want to look at the notice issue
And then
as
the
well.
notice issue. Yeah.
And we didn't discuss as much the life without parole. I know I brought that up early, and some people brought it. But
that to you, lawyer types.
what I would like to do, as we do a lot of times, is work with the committee offline. I think my understanding, and speaking with everyone, there's great support for the bill. So I would like to try to get a consensus.
Well, let me ask you this: since that's the only thing in question, if y'all decided that now, why could y'all not vote on those three amendments?
Well, we've got to get the language. I'm worried about how we get the language on the notice. Again, I'll take it. Yeah. We'll have to, we'll get a sub together to have if we need that language, we could look and see if the current notice language could be, could suffice. But we can have a sub we'll work with you on. It'll come to you. I won't bring you a sub you hadn't seen. So there's a time for that sometimes, but not on this. It's an important bill, and you've worked hard on it. And you have a right to express your frustrations, but it falls on us to make sure we get it in the right place. But we will get it done. Okay. I'm confident of that. All right?
I appreciate y'all's patience. I know it's
Thank you for sticking around. All right. With that, we are adjourned. Thank you.
Thank you.